morning and welcome back. This segment discusses California's new Parent Leave Act. And this act went into effect January 1st, 2018, and basically brings the California family rights leave for baby bonding down to cover smaller employers. There are a few differences with CFRA, not a whole lot as it applies to the baby bonding part. So the first thing you need to know with this particular leave is that it applies only to baby bonding, not to the other events covered by California Family Rights. And it's managed by Department of Fair Employment and Housing, and it applies to employers with 20 to 49 employees. The terms of the leave are pretty much identical. You have up to 12 weeks of unpaid leave to bond with your baby. You have health insurance under the same terms and conditions as were in effect before the leave began. And the employer does have the right to recover any premium payments it made for the same reasons as covered under CFRA. For example, the employee resigns for reasons unrelated to the leave. If you have two employees working for you who are both parents of this child, either placed with adoption or foster placement or by birth, then the two parents have a combined 12 weeks of leave. They can take it in any combination, but it is a combined 12-week maximum. Within 1 year of the child's birth or placement means that the leave has to be used up within those 12 months. Now keep in mind with the two parents working for the same employer. Under CFRA, there's an issue about marital status and so on. You just want to make sure before you apply that limitation on the 12 weeks, double check with an attorney who's familiar with California employment law. Make sure you're not in some way inadvertently discriminating between parents who are married and not. As far as the eligibility is concerned, they're pretty much, again, the same as CFRA. The employee has to work for the employer for 12 months or more, not necessarily consecutively, and they have to have worked for the employer for 1,250 hours within the previous 12 months. So in other words, you might have a seasonal worker, say a vineyard worker or a retail worker, who has worked for you for years and has more than 12 months of service with you, but still doesn't qualify because of the 1,250 hours in the previous 12-month period. So you just want to double check that. For exempt staff, we assume 40 hours a week. We do not count holidays and vacation days. It is hours worked. And for non-exempt employees, you actually count the hours that they have worked. Now, the terms of the leave, again, it's very similar to California Family Rights Leave. Basically, you use the leave in 2-week minimum duration. So the idea here is this is a new parent. It's not pregnancy. So the thought is, well, you would want to at least use 2 weeks at a time to bond with your baby. There are 2 exceptions. And you could foresee a couple of exceptions. For example, you have the child, you're placing them in daycare, and the daycare doesn't work out. And so you take a week to arrange for more daycare. Well, that could be a time when you need to deal with the baby, spend time with the baby, and it's less than a 2-week minimum duration. In general, however, this leave is not like medical appointments. This leave is to bond with a new child, and so you would use it in at least 2-week increments. But a parent could foreseeably use this in different times, perhaps 2 weeks in a month, and then 2 weeks the next month, and so on. Again, this leave is above and beyond any pregnancy disability leave. There is one item here that differs a little bit, and it may be corrected or changed at some point in the future, but right now, there is no 12-month limitation on the number of leaves. So conceivably, you could adopt a child in March and then give birth to another child in, say, November or December, and both of those leaves to bond with a new child would be covered. So what are the covered employers? They are employers with 20 to 49 employees within a 75-mile radius. Now, here's where it does impact large employers. You could conceivably have a large employer who had employees that were not covered by CFRA and are now covered by this leave. The example I like to use is Starbucks. They have a number of locations, but say that they have 3 stores in Nome, Alaska. There's nothing around Nome, Alaska. Previously, of course, it wouldn't have been CFRA, that would have been FMLA, but the same idea. Previously, they could have had employees who were not covered by protected leave. And they would now be covered by protected leave because they would be within that 20 to 49 number of employees within a 75-mile radius. This is fairly easy to see in communities out along the coast or in Siskiyou County, something like that. Now, employees can choose to use vacation, sick time, PTO, or unpaid time off during this parental leave. But here's another difference. Employers cannot require that employees use any of their accrued paid time during these absences. So an employee could conceivably save their vacation time or PTO and use that at another time unrelated to this particular leave. About reinstatement, pretty much the same as California Family Rights. You return the employee to the same or comparable position upon return. Of course, there's no retaliation for using the leave. A comparable position would be one with the same wage and promotional opportunities, career opportunities, but might be in a different department or perhaps a different location that's close by. The kind of documentation that we would need would be, again, similar to CFRA. These are under assigned documents in your module. And they would relate to you authorizing the leave. So the employee gives you a request, either verbally or in writing, says, I'm adopting a new child, I need to take time off. You review their status, their information, you make sure that they've covered the amount of time that they need to work for you. You send them an authorization letter. You want to make sure that you update your employee handbook to include this leave. If you're a smaller employer, of course, it's something new. If you're a larger employer, it may impact you in the locations that you have. So you just want to double check that. And then, of course, you want to train your supervisors on the leave provisions, just in general, so that they know when to call HR to handle the leave. I wouldn't bother providing supervisors with a whole lot of information because they don't retain it. It's not their job. You really don't need them to do that. What you need them to do is to pay attention to their employees going out on leave so that they can tell you when they do and you can handle the paperwork. For those of you who have facilities in San Francisco, you want to keep in mind that there are additional provisions within the city of San Francisco.